Everyone, and welcome. This is a very special event. Just 2 weeks ago today, we celebrated the anniversary of the birth of Dr. King. And we saw, both in this room and in other rooms, Dr. King at the Lincoln Memorial. Ironically, Abraham Lincoln and Charles Darwin were born the same day. And so there has been this outpouring of interest in these two very large, extremely different figures who have had such an enormous influence on the intellectual and political life of our country and indeed of other countries as well. So we're very grateful to have two very special guests who will be engaging in a conversation on the influence of both Mr. Lincoln and Charles Darwin. So to set the stage, would you join me in welcoming our on dear, he does it all, historian, healthcare law, property law, our own Pulitzer Prize winning historian and professor and friend, Ed Larson.
Well, thank you all for coming. First, I want to thank Dean Starr for catching this idea and running with it and being so involved, in his dear wife, Alice, for having the front table party up to their house for a wonderful end of the Super Bowl, though Dean Starr didn't think it was a wonderful end, but almost to the last minute, wonderful end for the Dean, and dinner. Our Vice Dean, Tim Perrin, who has been absolutely instrumental in making this happen. It wouldn't have happened without Dean Perrin. He's been tremendously enthusiastic about it. And then, right in the beginning, rather than waiting to the end, Morgan Thrower and Kylie Larkin have put all the pieces together. They've done all the contacts, they've done all the arrangements to get these two very busy people here, and all of you here, and getting all the notice out. So they deserve enormous credit. Thank you. I see Morgan there. Pass on to her too. Well, let me, now, as the Dean said, there is this coincidence of the birth on February 12th, 1809, of Lincoln and Darwin. Now, this has been widely noted. If you catch the current issue of the Smithsonian magazine, you'll see Darwin and Lincoln. They have the pictures back, but I think they did a reversal. They must have done a reversal of the picture to get them to look that direction. But there they are, and this covers, there was a large article in the New York Times on Sunday, in the LA Times, a different one in the LA Times. If you look to the inside of the Smithsonian magazine, to the article, it calls it Twin Peaks. Their shared birthday is an intriguing coincidence. But what truly unites Darwin and Lincoln is how they shaped the modern world. Well, that's what we're looking at today, and we have two remarkable speakers to be able to introduce this topic to us. And I'll introduce them and then do a little introduction of the topic. Dan Farber is the, let me hope I pronounce it right, the Sato professor? Sato, professor of law at the University of California. He was a former U.S. Supreme Court law clerk to Justice John Paul Stevens. He was the founding editor of the premier journal in its field, Constitutional Commentary, the premier peer-reviewed constitutional law journal in this country. He's the author of over 100 published articles. I gave up counting at that point in his CV, and 16 books, including, for our sake, the most important one for our purposes, Lincoln's Constitution, which inspired, this book is what inspired me to think about having this conference. Now, Laurence Claus is on the other side, as I should say, is professor of law at University of San Diego, former clerk to the well-known U.S. Appellate Court Judge Frank Easterbrook, attorney with the Justice Department's Office of Foreign Litigation, and author of numerous scholarly articles in constitutional law, legal philosophy, and jurisprudence, including, most importantly for our purposes, and what inspired me to think of him, a forthcoming article that deals with the impact of evolutionary thought on legal realism. At the end, what the format is going to be is we're going to have Professor Farber give an opening talk, and then Professor Claus give a responding opening talk, and then a brief rebuttal period for Professor Farber, and then your questions for half an hour, where you can direct them at either one of them or any of us. And then a brief concluding remarks by them. And then, if you'll bear with it, we might just take a vote at the end. Your handheld vote to think, not which of them won, but who you think had a greater impact on American law based on their comments. But before I turn the podium over to our distinguished speakers for a friendly debate over the relative importance of Lincoln and Darwin on American law, allow me to set the stage by briefly taking you back to February 12, 1809, 200 years ago next week, when Lincoln and Darwin were born. The former in a cabin on the American frontier, and the latter in a country manner common to the rising English gentry of the day. Democracy was on the run in 1809. A seemingly failed idea in the wake of the chaotic violence of the French Revolution and the rise of Napoleon in Europe after the experiment with democracy in France. The divine right of kings and a fixed social order looked increasingly good to many people, or if not good, at least better than the alternatives. Despite a sincere effort by Jefferson to restore the democratic idea in America, and we should remember, Jefferson was still president when these men were born, people questioned its viability even in the United States, and for good reason. Earlier in the decade, one of the leading architects of our Constitution, Alexander Hamilton, began calling for a hereditary American monarchy and a House of Lords to balance what he saw as the destabilizing effects of excessive popular rule. And he was subsequently killed by the sitting vice president in a duel. England was waiting for the American experience to collapse, and 3 years after Lincoln's birth, invaded our country and burned our capital in an effort to subdue us. Fixity rather than change seemed the order of the day, and attempts were made to forcibly install it in Europe following Napoleon's defeat by the combined monarchies of Britain, Austria, Prussia, and Russia. And even in the United States, where it hung on, democracy had a near fatal flaw in the radically undemocratic institution of chattel slavery, under which a person's birth meant everything forever, even their legal personhood, with no chance for change or evolution. Despite his rhetorical commitment to equality and his youthful questions about slavery, even Jefferson had come to accept the institution as a necessary evil. Under creationist biological thinking, he had joined with other Southern naturalists, and some in the American North and Europe, to accept a separate creation for Africans, which he used to justify their ongoing enslavement. Despite his birth in a slave state, Lincoln would become one of slavery's most eloquent and effective critics. And in Britain, where evangelicals had taken the lead in opposing it, Darwin, who was steeped in that Christian anti-slavery tradition from his mother's and his wife's side of the family, was repulsed by the static creation in biology in part for the reason that it supported slavery. When Christians in his family would question his ideas of organic slavery, he loudly and repeatedly pointed out that a common origin for all humans was the best scientific argument against slavery. Static land trust, primogeniture, and limits on capitalistic ventures also clung to the law in both England and America. But Lincoln and Darwin challenged them, as they did monarchism and slavery. They were both from the rising classes. It was simply that Darwin's had risen much further by 1809. Both staked their economic future on capitalism, with Lincoln joining the business-friendly Whig Party and Darwin investing and profiting heavily in English industry. He was, after all, a Wedgwood on his mother's side and by marriage. In 1809, change was in the air, political, economic, social, and most of all, for our purposes, legal. I'll turn it over to our speakers to debate which of these twin peaks of 19th century thought had the greater impact on American law, beginning with Professor Farber's case for Lincoln.
Thank you. It's a great pleasure to be here today. I understand that the weather is usually better than this, but I can't imagine how it could be. I'm especially grateful to Ed Larson and Dean Starr for making this possible. Dean Starr and I go way back. We actually were both law clerks together, as it happened shortly after the Lincoln administration. So it's good to have the chance to reunite. It's very hard, when we ask about the impact of Lincoln on American law, I suppose one way of answering that would be to ask, suppose Lincoln hadn't been there, what would the world look like? And this kind of alternative history keeps science fiction writers busy and allows historians to debate each other after they've had a few drinks about how history would have worked out. And of course, we'll never know. Would the Republican candidate for president have been weak enough that Stephen Douglas could have picked up some northern votes and somehow won the election? Who would have been president instead, and how would they have responded? How would the South have responded? I think, frankly, there's no way of telling. One of the underlying questions, I guess, is whether the Civil War was inevitable or whether it might have been somehow avoided. It certainly looked like things were moving in the direction of civil war pretty inexorably around 1860. But you can imagine a history book saying, although things looked bad in the late 1850s and early 1860s, war was avoided, and then whatever. We'll never know. I'm dubious of that. I belong to the irrepressible conflict school. I think that the legal, moral, and social gap between the northern states and the southern slave states was just too great to be peaceably bridged. But we'll never know if that could have happened. Lincoln had, or at least Lincoln's presidency, saw a number of really important innovations in American law. It was the first income tax. It was the first time that the U.S. issued paper money. It was the first military draft in American history. And there were a host of other significant legislative advancements, but that's not what I'm going to talk about today, although I think you could make a case that those in their way were critically important. Instead, I want to talk about Lincoln and the Constitution. And I think Lincoln, and both his thoughts, words, and actions had a tremendous impact on American law and American constitutional law, focusing on federalism, separation of powers, and individual rights. Now, I guess you could say, in fact, we're not sure if there would be such a thing as American law, except in the sense that you can talk about Asian law or European law without Lincoln. We have no way of knowing whether anything that looks at all like the United States would exist today. It could be that that we would have a bunch of 4 or 5 regions and maybe a couple in Canada and some kind of NAFTA agreement to deal with trade issues. Who knows? But putting that aside, I think we can see how Lincoln and his views and his actions, which I think have to all be considered together, really transformed our understanding of the Constitution. And one way we could start by thinking about some of these impacts, I think, is to take a look at the Pledge of Allegiance and sort of walk through the pledge and see how, in a way, that pledge only became possible after Lincoln and as a result of Lincoln. So let's begin with the beginning. I pledge allegiance to the flag of the United States of America and to the republic for which it stands. Well, you couldn't really have said that in 1859.
And the reason you couldn't have said it was at least twofold. One was, it's not clear to whom your allegiance ran. There were quite a number of people, including some well-respected political theorists and constitutional thinkers, who thought that who you owed allegiance to was your state. I pledge allegiance to the state of California and the republic for which it stands. Or, in Robert E. Lee's case, the state of Virginia. And famously, he felt compelled, Lee did, to join the Confederacy because he had to stand with his country, and his country was Virginia. That was not such an eccentric view. There was, in fact, good authority that citizenship, which is your basic allegiance and duties as a member of a political body, that citizenship was primarily state, and that you became a federal system basically because you were a citizen of one of the United States. In fact, some people, I guess, would have given the pledge more like, I pledge allegiance to the flag and to the republics for which it stands. That dispute, I think, was pretty decisively settled by the Civil War, which was primarily, at least to the extent that it was, that you can sort of disentangle the issues that were involved, but in a really important way, it was a war over allegiance, over whether Southerners had an overriding allegiance to the United States as citizens, or whether their primary allegiance was with the state government, and similarly in the North. And then, of course, we get to the next phrase in the pledge, which raises the Civil War question even more decisively. One nation, indivisible. Now, one question that could seriously be asked was whether it was appropriate to speak of the United States as a nation. And in fact, people like John Calhoun and Jefferson Davis considered this to be loose language, sort of like speaking of the European Union as a nation, right? That essentially the United States was a confederation of state governments formed to advance their joint interests, but essentially a creature of the states. Occasionally you find echoes of this theory even today. There's an opinion by Justice Thomas, a dissent in the term limits case, that picks up some of the language of that argument, although I would be very surprised to learn that Justice Thomas doubts the existence of the United States as a nation. But I have been surprised before. Lincoln's theory is an interesting one, and one that slips by us. If you remember the Gettysburg Address, we all know it begins 7 years ago. And we tend, I think, to believe that 7 years ago was when the Constitution was adopted, maybe when George Washington took office, something like that. But no, 7 years ago, if you do the math, was 1776, the Declaration of Independence. Lincoln believed that the states never existed as independent sovereigns. They were always part of the United States, and that the United States became a nation as soon as it ceased to be a set of colonies. And that's why he thought that that was the year when our forefathers brought forth a new nation on this continent. Calhoun and Jefferson Davis believed, on the contrary, that the United States never really became a nation. And an intermediate position, which I think you can find supported by some of James Madison's writings at least, was that the United States only became a nation with the adoption of the Constitution. That it was only at that point that the federal government became a true government, rather than a kind of confederation. Mostly it doesn't make any difference, even in terms of theory, whether you adopt Madison's view or Lincoln's view. there are very few legal questions that would ever turn on the difference between 1776 and 1790 as the date of nationhood. But there is a big difference between thinking that the United States is a plural and thinking that it's a singular. One of my colleagues at Minnesota, a civil procedure professor, very distinguished, named Jack Hound, was fond of saying that this was one of the questions that was decided in the landmark case of Grant versus Lee, one at the courthouse, 1865. And I think there is something to that, that at some point this was not going to be a dispute that you could settle with logic and recourse to history books. This was a dispute that had to be settled the hard way, and was. That settlement, that decision is memorialized in the 14th Amendment. The first sentence of the 14th Amendment makes all persons born or naturalized in the United States and subject to their jurisdiction citizens of the United States and the state where they reside. And then it goes on to guarantee them the privileges and immunities of citizens of the United States as against state governments. So that sentence makes it quite clear that federal citizenship is primary. State citizenship is acquired only as a result of being a U.S. citizen, and that it carries with it privileges that are good as against the states. And then we come to with liberty and justice for all. And that's certainly not something you could have said before Lincoln's presidency. As Ed was just reminding us, this was, until then, a nation in which millions of people, a large share of the population, in fact, had neither liberty nor justice. And in which the Constitution itself, if it didn't endorse that state of affairs, certainly accepted that state of affairs. With the Fugitive Slave Clause, the 3/5 clause, and other portions of the Constitution. And in fact, even apart from slavery, the fact was that the United States as an entity did not guarantee significant rights of citizens as against the states. There were some clauses about the impairment of contracts, about bills of attainder, and so forth, but essentially, to the extent that you had any rights against state government, it's because the state constitution chose to give you rights, not because you had rights as an American citizen, or as even a person living in America as against state governments. Lincoln clearly had a different vision. At Gettysburg, he said that the nation was conceived in liberty and dedicated to the proposition that all men were created equal. And you can see why 1776 was a better year to attach that to. The year of the Declaration of Independence, rather than of the later Constitution that accepted slavery. But he believed that these were the key functions of government, and that the American Union was dedicated to those functions from the start. And again, we see ultimately that these become part of the Constitution with the 13th Amendment, which abolished slavery, something that was unimaginable a few years earlier, with the 14th Amendment and its guarantee of due process of law and the equal protection of the laws, and the 15th Amendment, which guaranteed the right to vote for the former slaves. So we see a real transformation in which I think Lincoln would have said that the U.S. within the constitutional regime was redeeming the promise that America had made to the world and to itself in 1776. And he always viewed the Declaration as being a more fundamental charter for America than the Constitution, which he viewed as relatively utilitarian. It was a way of getting there. It accepted some necessary compromises, but it wasn't really the vision of America. He saw that as being an earlier document. So I think both in terms of individual rights and in terms of the federalism, really the current constitutional order is firmly rooted in Lincoln's vision. Now another aspect of Lincoln that I think needs to be discussed separately is his impact on the office of the presidency. Historians, it's very hard, try to think of the 19th century presidents in order. And even if you're pretty good at American history, it's pretty difficult because there were a lot of really obscure characters between Jefferson and Teddy Roosevelt. And let alone try to say something about what they did or which party they represented or anything else. You have to be a real expert, I think. Or maybe have recently studied for the advanced placement exam in order to remember those things. 19th century presidents, by and large, were not a big deal. And President Buchanan really epitomized that, I guess you could say, as one of the weakest presidents in American history. The president was still thought of by many people as a servant of Congress, somebody who carried out congressional directives. Now, it's certainly not true that Lincoln was the first strong president. Jefferson had made the Louisiana Purchase. There had been the Neutrality Declaration under Washington. Jackson at least made an awful lot of noise. You know, I think promoted a kind of image, at least, of the strong president. In many ways was stronger previously. First president ever to claim that he could veto a bill just because he didn't like it. Previously, it was thought the president could only veto bills if he thought they were unconstitutional. So Lincoln was not alone, but Lincoln, I think, towers above them in terms of what he did, what he was perhaps forced to do by the times, especially in the early years of the Civil War. And the early weeks in which Congress had not really been in a position to come forward. Fort Sumter was in April, and Congress didn't convene till July, and even when they convened, as is their way, it took them a while to get things done. In the meantime, all by himself, Lincoln had called out the militia, expanded the regular army, ordered new ships to be constructed for the Navy, spent millions of dollars, imposed a blockade against the South, which was clearly an act of war, suspended habeas corpus, initially just in the DC and Maryland areas, but later on a broader scope, and so on and so forth. He essentially took the nation to war by the time Congress ever convened. During the war, he continued to remain very active, both on direct military matters, on Reconstruction policy, in a way that previous presidents had not. And he became, I think, a kind of role model for later presidents. Now, there's endless debate about what the Constitution originally meant to give the president. And I think, from our purposes, the most significant thing is not what the right answer is, but just that there's endless debate. That the record is sufficiently ambiguous that we can still argue about it. But what we can't argue about is that the presidency today is the first among three co-equal branches in terms of the ability to initiate policy, in terms of leadership of Congress, and in terms of foreign affairs and national security. We continue to argue about the proper limits. Sometimes switching places depending on who's in the White House. One of my colleagues who was a vigilant supporter of the executive power until November recently published an op-ed about the need to rein in the president. And I don't think he's alone. I'm sure there will be people on the other side who will rediscover the virtues of presidential initiative. We still argue about this. But what I think we can't argue about is that the presidency has become a significant institution, not just because of whatever Madison thought or whatever the legal definition of executive power was in 1790, but because presidents, beginning with Lincoln, have made themselves not just the head of one branch of government, but the leaders of the government. And I think we owe an important part of that development to Lincoln, too. So just briefly to summarize, I think that our constitutional order today, as we live it, not just the words in the Constitution, is hard to imagine without the contribution of Lincoln and of his generation. in some ways, I think that we can view Lincoln as much the father of the Constitution as we know it today as of James Madison, who was considered to be the father in 1789, and whose vision did so much to shape the Constitution. In fact, I argue in the paper that I think you've had access to that, in fact, you can see Lincoln is completing what Madison started but was unable to finish himself. So I didn't come here really to argue against Darwin or his influence, but it's hard for me to see how any reasonable person could fail to view Lincoln's towering role in American constitutional history. Thank you.
Thank you, Dan. Professor Farber's account of how Lincoln used his presidency to preserve the Union and to clarify its character makes me want to hear his view actually on the much debated question of where abolishing slavery and raising up the civil rights of the enslaved really stood among Lincoln's priorities. Lincoln's commitment to preserving the Union and strengthening the national government comes to us sort of hallowed by the fact that it accompanied the abolition of slavery. But from much of what Lincoln had to say about preserving the Union, one gets the impression that if the South had wanted to leave for some other profit-making reason, that wasn't slavery, let's just say they discovered a whole lot of gold and they didn't want to share it, didn't want to pay federal taxes on it, Lincoln would have been just as ready to stop them, just as ready to go to war, to make them stay. And that choice gets retrospectively hallowed and sanctified by the sheer cruelty and wickedness of the particular profit-making practice that the South was seeking to perpetuate. Notice that today, when a geographic segment of some other society wants to break away, we generally urge the central government to let them go, right? Or we certainly get a bit cross when the central government violently prevents secession, right? So just imagine for a minute if a CNN camera crew of the kind that documented Bosnia or Kosovo had followed William Tecumseh Sherman through Georgia. Would the world of the day have viewed Lincoln any better than today's world viewed Vladimir Putin when Russian tanks rolled through another Georgia? Right? But Lincoln's great accomplishment is that he achieves these big legal changes that Professor Farber's described, drawing maximum support from the moral sickness of slavery. And he can do this because he's so eloquent, right? And when we read that preliminary version of the Emancipation Proclamation in 1862, here's the thing that in substance is, it could be called kind of cynical, right? It's a bit of a trick to gain a wartime advantage. He is only freeing the slaves in the rebelling states. It's not yet freeing the slaves in the loyal border states, right? But this thing that could be viewed as a bit cynical gets sort of sanctified and raised up by that alliterative crescendo at the end, that the slaves are to be forever free, and we're raised up to the moral heights. And so yes, we owe much to Lincoln for our current understanding of what American constitutional law's structure and details should be understood to be, and the extent to which power should be understood to be centralised in this country. To Charles Darwin we owe a different debt. From his theory of evolution, we have discovered, as never before, or are discovering, what law is, the nature of law. And that discovery, I'd like to suggest, was most prominently introduced into our legal system here in the United States by Oliver Wendell Holmes in his famous description of law as a body of systematized prediction. Now, to see the difference that Darwin made, I'd like to take you back over a century before Darwin was born, to 1690, when John Locke anonymously publishes in England his two treatises of government. So I want to tell you a little bit of story about that. Locke opens the preface to these treatises with a hope that the writings are, quote, sufficient to establish the throne of our great restorer, our present King William, to make good his title in the consent of the people, which being the only one of all lawful governments, he has more fully and clearly than any other prince in Christendom. Sounds good. Well, it wasn't really obvious. This guy, William, had turned up the year before with a foreign army. And that had prompted the king, James II, to bolt. He'd gone off to France, where Louis XIV had helped him out, set him up with resources to head over to Ireland and build a rival army, which was then assembling in Ireland when Locke published. And it was true that many among the English elite were kind of happy that William had arrived, and the English Parliament had offered William the English crown to be taken up jointly with his wife Mary. Mary was actually the daughter of the previous King James. But that didn't really demonstrate the consent of the English people, because back then hardly anyone got to vote, right? I mean, only men who owned substantial property had a say in who got elected to Parliament. And William's success in persuading Parliament to offer him the crown might have had a little bit also to do with the fact that he had an army, right? and no one else in England did at the time. So let's also look at Locke's publication timing. Locke's choice to publish these treatises, what he did, suggests that he saw a need to persuade many people in England that William should be recognised as the king and should be obeyed, which implied that the audience hadn't yet actually promised to obey, right? Hadn't consented. You wouldn't have needed to persuade them if they had. Now, Locke had really strong reasons for thinking that this newcomer William would be a better leader. He would just do a better job of governing England than James had. And he was pretty personally invested in William's success. William was from Holland, and Locke had been in exile in Holland prior to this change, and Locke had been able to come back. Locke had previously been expelled from a tenured job at Oxford, and we academics really do not like having our tenure messed up. So Locke was very happy with this change, right, and very unhappy with James Stewart, the previous guy. So given that that was true, why didn't Locke just simply set forth the reasons for thinking that William would be a better leader? Well, what's so hard about that? You know, we sit through election campaigns where that's done all the time. Why did he make this consent argument in support of William's kingship when the argument was so obviously a big stretch? Any reasonable fact finder would have had to conclude that there was insufficient evidence to show that the people of England had promised to obey William and treat him as the king. So why did Locke say that they had, and why did he make that the centrepiece of his case for William's kingship? And the answer lies in Locke's understanding of law and government, of how we get law, and of what counts as government. Locke thought that he had to explain how William's rule could be consistent with a government that was good, that was moral. And he thought that that was only possible. You could only call a government good. You could only call it morally justified, legitimate if you like, which is the fancy word we use when we just mean good normally. But in order to say all that, he had to identify a moral right coming from outside the legal system to create law and to create government. In other words, he had to identify an outside source of a moral right to be obeyed, which is, we often use the word authority for that concept of someone having a moral right to be obeyed. And when we say a right to be obeyed, I mean the exasperated parent phrase, because I said so, right? Not simply someone who's filling you in on what would be the best thing to do anyway you then independently see, right? Not someone who's just giving you good advice. I mean someone who has a right to be obeyed even when you're thinking, something else would be the better thing to do, right? Now, Locke thought that you couldn't really have morally justified law and government without the notion that the lawgiver had this some basis for having a moral right to be obeyed in that strong, preemptive sense. And there was a very clear prevailing idea about what produced such a notion, such a right to be obeyed. What gave the right to create law? What gave the right to constitute government? And it was expressed in the English monarchy's age-old motto, which of course was actually in French, de et mon droit, right? God and my right. The idea was that God had created humans to do his will, and God had appointed human leaders for his creation. And it was sort of intuitively plausible to think that when you create something, that gives you a right to use it as you please, right? So the concept at its core was one of property. Humans belong to God. Humans are their creator's property. Property rights can be delegated to human leaders for their better use, their more effective use. So if you were going to displace divinely chosen human leaders by ignoring, say, succession principles, well, you would be defying God, and you would be risking a withdrawing of God's grace and blessing upon the nation, right? And so even if those who had or seemed to have, or could say they had, this divine right to rule, even if they seemed stupid or even evil, that didn't really justify revolution. And Scripture could be quoted in support, right? Cited often was David's refusal to harm the flawed King Saul, right? Remember the biblical text? Who can stretch forth his hand against the Lord's anointed and be guiltless, right? Now, associated with that property idea in the Judeo-Christian tradition was an expertise idea, based on the idea that God knows best and wants what is best for his creation. If the creatures thought that alternative candidates for leadership, who might just do a better job, they were necessarily wrong, right? Because God knows best. And the idea of expertise has continued to figure in theories of authority, most recently in the theory of Joseph Raz. But fundamentally, there are a couple of problems with thinking about expertise as giving a right to be obeyed, even though we do often call experts authorities. You say he's an authority on Ed Larson's an authority on the Scopes trial. But that is a use of the word authority that in a dictionary is just distinguishable from the use of the term to denote a right to be obeyed. Expertise is mastery of knowledge, right? Not mastery of persons, and the one does not imply the other. If your doctor tells you to stay home from work because you're contagious, your duty to stay home from work is owed not to your doctor. Who's it owed to? Co-workers, right? Yeah. Your doctor's advice, information gives you the right thing to do, but that doesn't give the doctor a right to be obeyed, right? I don't owe my doctor any more obedience than I owe the authors of Wikipedia or any other information source, right? Second, human governments and human law are obviously not consistent guides to goodness, right? Which is factually clearly not the case. If they were, then totalitarian government might, have a plausible claim to being good. Now, back in 1690, when arguing against the divine right, alleged divine right of bad King James, John Locke thought he needed an alternative way to say that William had an outside source of right to be obeyed, an alternative to the property idea that underlay James's claim. And Locke's alternative was contract, right? A right to rule that rises from the ruled rather than descending from the divine. But as scholars since have well explained, lots of insights about this over the couple hundred years following Locke's articulation of the consent theory, a consent theory doesn't really work in satisfyingly conferring a preemptive right to be obeyed. Myriad angles from which it can be assailed, but I'll just mention a couple. One, a promise to obey does not make morally right what would otherwise be morally wrong, right? No one can, you can't just morally promise to do whatever those in government will thereafter ask of you, however bad, right? It's not a moral thing you can promise. If you promise it, you've done an immoral act. If government asks for it, they're being immoral, right? They have no right to ask for such an open-ended moral blank check. Another point we could make is that government is what government does. So, you know, if I promise to obey the Constitution and laws of the United States, and tomorrow the Constitution and laws are changed, whether in their words, formal words, or just in the way government actors treat those words, right? If government actors treat the words of the Constitution as achieving things that were previously not what the words were treated as achieving, have I consented to this new form of government that now is operating in the country? I mean, if I moved to Germany in 1930 and promised to obey the duly elected government of Germany, did I discover 3 years later that I had obliviously promised to obey the Nazis? Okay. Third point. For any large community of humans, any claim that all or even most members of the community have consented to that community's law and government is just going to be factually untrue. Right? Most people in most communities never promise to obey their law and government. And staying in the community in which you were raised does not plausibly imply a promise to do whatever the community's law and government requires of you, because hardly anyone on this planet has a choice about whether to stay. And even those of us who do have a bit of freedom to move about a bit, some of us who, from an accent or two, you might tell have moved about a bit, you can still, it's still the case that, you know, a limited range of choice. Imagine if you were a Jewish person fleeing the Spanish Inquisition. Would you feel that you'd consented to the laws that still discriminated against you, somewhat less, in the place to which you fled? And finally, let's be clear, just for now, that just because some means of constituting and operating government are morally better than others, you know, democracy is better than dictatorship, we might all agree, that doesn't imply that the people who run a democracy have a because I said so right to be obeyed. They run the democracy, but that doesn't imply that they actually have this special status. Maybe we only have to follow them when they're actually telling us the right thing to do, right? Okay, so what difference is the question for today? Would it have made to John Locke's case for William if Charles Darwin had lived first? If Charles Darwin had preceded John Locke? Because Locke's dilemma in seeking to support a revolutionary change in the government was that non-creationist ways to think about the emergence of law and government were no more within reach for him than non-creationist ways to think about the emergence of humans. Had Locke read The Origin of Species, he might have been able to imagine law and government as coming from something other than an outside source of right to be obeyed. If we just look at the conflict between William and James, that was this backdrop, the factual backdrop to Locke's theoretical story about law and government. At the time it was characterised as a big moral dispute about goodness in government and how government ought to be run. And the evolution of our communicative capacity as humans facilitated that kind of framing of their story. But if we peel back all of the rhetoric of the time, all the things they said about each other, and we just look at their actual behaviour, and of course we could do this with campaigning politicians over the past year, you know, if you just peel back all the rhetoric and look at how they actually just behave, and one sees that that behaviour rather resembles the manoeuvring among dominant males that can be witnessed in the chimpanzee enclosure at the San Diego Zoo. There are negotiations and agreements, but hardly any of the affected populations have any say in those negotiations or agreements, right? Locke had argued that government in human communities first emerged through contract, and maybe that was true. But what reason was there to think that the deals differed in any way, really, substantively, from the deals that Locke could actually see around him, right? King James's negotiations and agreement with King Louis. William's negotiations and agreement with the disaffected English aristocrats. I mean, wasn't it much more plausible to think that we got leadership in human communities through a mix of violence and negotiation among the few community members who'd had the best days at the gene pool? You know, the ones that were strong enough to win the fights, smart enough to make a good speech, most closely related to those in the preceding generation who were similarly situated. What those people signalled would, through the evolving communicative ability of humans, would soon enough be self-fulfillingly most likely to happen. And so their identities would become interweaved with emerging conceptions of law and government. So within a Darwinian evolutionary conception of human communities, law and government are just integral to what it means to evolve human community. We started communicating with each other. Particular communications that we now call law appeared within human groups and reciprocally defined those groups in this way, we can imagine. Particular persons who possessed distinctive abilities to persuade and to coerce, great communicators and physically powerful people, were treated as leaders within groups of humans. And what those persons signalled to others in the group became the best evidence of what was likely to happen, the best predictions of human behaviour within the group. As groups grew, leaders signalled others whose signals would also supply good evidence of what was likely to happen, right? Chiefs appointed deputies, judges and other officers, and as signals referenced other signals, hierarchies of signallers and signals formed, and so we evolved communities defined through self-generating, self-referential systems of signals. Within an evolutionary conception, what makes particular communications the law of a human community is that those communications are part of a self-recognising system of signals that tells members of a community what others in the community are likely to do. So law's function on this view is not to implement someone's independent, externally derived right to be obeyed. Rather, law's function is simply to inform of the likely attitudes and actions of others, including others in government. Lawgivers arise through creation, not through creation, through evolution, in the sense that the status of becoming a lawgiver doesn't come through some external source of right to be obeyed, but from the system itself recognising a person to be the issuer of systemically pedigreed signals. The value of law on this view comes to us wholly through the information that it supplies about the likely attitudes and actions of others. That information invaluably assists us in making our real moral choices about what to do because it supplies forewarning. It enables prediction, or as you will all ultimately say, legal advice. Right? Which is what else but prediction of what will happen in the future based on what the law tells us. An evolutionary understanding of law explains the legal status in human communities of custom. Custom can be recognised as law without the kind of awkward argument that John Austin made before The Origin of Species, that the only reason customary law was because the sovereign endorsed it. Now we can see, after Darwin, that custom was always law, and that institutions of government develop like organisms, developing in an evolving species whose earlier cell divisions had already visibly generated custom. Government institutions derive their identities from custom, from a particular custom of treating communications from those institutions as part of the system that signals what people are likely to do in the community. In other words, the common law is our ultimate constitutional foundation. The proposition that statutes and regulations are the law and trump custom is itself a proposition of the common law. Now, Darwin's impact on how we understand law in America can be traced to Oliver Wendell Holmes in the first instance, I think it's fair to say. And it got to Holmes through a chap called Chauncey Wright, who was a Boston-based intellectual who corresponded with and visited Darwin in the wake of reading The Origin of Species, and who became a leading American exponent of evolutionary theory. And in the early 1870s, Wright co-convened a scholarly group that became known as the Metaphysical Club, and Oliver Wendell Holmes, young Oliver Wendell Holmes, was a very active participant in this group. And from Holmes in the decades that followed, we receive a new realist vision of law. It's a vision that discards the old idea of some outside source of a right to be obeyed that identifies lawgivers and lets them create duties to act. It's a vision of self-generated value. Right? The system itself supplies reasons for doing what it signals, namely the likely attitudes and actions of others, both those others in government and one's fellow citizens. As Stephen Perry has aptly put it, for Holmes there really are, quote, no such things as legal rights and duties. Law's language of right and duty just signals what people are likely to do. It's a forewarning and predictive advice. It self-fulfills its prophecies, and so it self-generates its value to its community. The common law of contract and tort, as you've all studied either recently or a little bit longer ago, it remains heavily embroidered with duty talk. Lots of talk about duties. But in Holmes's words, the duty to keep a contract at common law means a prediction that you must pay damages if you do not keep it, and nothing else. And that insight, of course, has been expounded a lot in more recent times by the law and economics movement. The real reason that we regard a statute, even when written in morally neutral language like, it shall be an offence to kill, as signalling something that's truly non-optional and obligatory. While we treat a common law opinion that expresses a duty to perform as signalling perhaps something that's actually quite optional, is that we don't really believe that our answer comes from a general moral duty to obey the law. We recognise ourselves usually to have an obvious moral duty not to kill that would exist regardless of what the law said. We do not recognise ourselves to have an obvious moral duty to perform all contracts, or at least those of us who sat through law and economics workshops at UChicago don't think we do. So for us, the true substance of law lies not in moral instruction one way or the other, it lies in prediction. And that's the distinctive value as law that human communications have to their recipients in the human communities to which they belong. So to sum up, we ultimately have Darwin to thank for these kinds of insights about the way law works. Evolutionary thinking explains law's origins in custom, explains how communications within a human group become the law of a human community, and explains the value that law has to its community, the value of systemically signalling likely action within that community. While Lincoln's conduct of his presidency significantly shaped our vision of American law's content, Darwin's account of evolutionary development offered an alternative and more accurate vision of what law is, indeed of what both law and government essentially, inevitably, universally are. Law and government exist whether or not there is justice and democracy. Law and government exist just because there is human community, and Darwin explains how.
We'll have a brief comment back by Professor Farber, and then Dean Starr will entertain questions.
Well, I'm not sure that either Darwin or Lincoln can be given responsibility for the Chicago School of Law and Economics. And I'm not sure of what Darwin thought about law in particular. But I do think there's a very significant point to be made about Lincoln's view of law and legitimacy, which is quite different than the one that we just heard. Lincoln thought that, in fact, it's important for people to obey the law even when it's inconvenient or even when it's morally troublesome. Not absolutely, right? He recognized that there were some limits at which you might rebel against a government or in which obeying one law would be so disastrous that it might have to give way. But as a general matter, he thought it was quite critical that people in a democratic community, and especially leaders in a democratic community, obey the law and respect democracy. His fundamental objection to the South was slavery, but his fundamental objection to secession was that it is incompatible with democracy if any minority that loses an election, for that reason alone, feels free to pick up their marbles and go home. We don't know how that would have played out. There were some individual counties that seceded from southern states. Would that secession ultimately have been recognized? Would anything have remained of either part of the United States if everyone adopted the principle that they would accept the result of elections only when they agreed with the outcome? Lincoln, I think, felt it especially important for leaders. He gave a speech early in his career about how the only real safeguard of democracy against the kinds of strong alpha males, the Napoleons, was a rigorous, unwavering belief in law. And that, I'd like to talk more about slavery and the Civil War, but maybe I'll leave that if there are any questions. But one of the strong reasons that he gave for extending the emancipation only to states that were still in rebellion was that he believed that he could justify that act of emancipation as a matter of unilateral executive order based on the war power, because of the right of an army to use whatever means were necessary to military victory. And he didn't think that that constitutional justification applied to states that were already safely under Union control. I think that, and also his attitude toward the Fugitive Slave Clause before the war, I think both illustrate what he viewed as the gap between what might be the best thing we would like to do, the most moral outcome we would like to see, and what the law sometimes requires of us. Again, he was not certainly a legal philosopher. I don't suppose Darwin was either, but I do think that there's a real difference there in the sense of whether law is in some sense binding, even on the powerful, even on those in the White House, or whether it's only something that is binding on other people because they don't have enough power of their own to ignore the predictions of the community response. So I think there is a big difference there. I think it'd be hard to say which view is strongest in America or American law today. Even within the Chicago school, I think would find disagreements. Frank Easterbrook seems to think that legitimacy and legal authority are important. Richard Posner thinks that they're pretty much mirages and that we should be guided by utilitarianism on all occasions, or economic efficiency. So I'm not sure that our society has really settled on an answer to this question, but I think it's one that we continue to confront, and that these two opposing viewpoints, I wouldn't say necessarily that one has triumphed, but I think that they're both important to understanding the debates that we actually have about things like whether presidents should obey federal statutes and that sort of thing. So I think that's about enough to set the stage for questions. Thanks. Well, the floor is now yours. In contrast to our usual proceeding, which is a National Press Club Write Your Questions Out, welcome to the Agora. So all you have to do is to raise your hand and pose a question to one or both Professor Cochran.
This is a question for Professor Claus, and I guess it's a simple question. How do you think your colleague Steve Smith would react to what you just said?
You might identify who Professor Steve Smith is.
Others, let me just try my hand at what Professor Smith might have said. The question that we're asked to address is who had the greater impact on American law? And it's a bit ambiguous. Does that mean American legal theory, or does that mean American law as practiced and as ordinary citizens perceive it? It seemed to me that your argument was that Darwin had an impact through Holmes on American legal theory, and in American legal theory, generally through the realists and critical legal studies, and you mentioned law and economics, the notion is that law is just power. But Smith argues that the actual way that lawyers practice law and that people perceive law is that in fact law is divine authority, something that Abraham Lincoln would have been much more comfortable with, that there's a natural law, higher law that that law should conform to. And so I'll leave it to you. You know, what's your reaction to that notion?
Yeah, I think I think you can all hear me if I just sit here. It's okay. Yeah. There's a tension, I think, perhaps in the psyches of many of us between two instincts about these things. We certainly think that law needs to be taken very seriously as a guide to action, but quite what the character of that perception is as part of the debate, right, as to what it is that we are doing when we treat law as an independent source of a reason to do something. The reasons law gives us for doing things include the sort of content-independent reason that this system is clearly essential to our well-being, right? Having an efficacious legal system, a system that really guides us about what others in the community are likely to do, is a critical factor in economic success and general community well-being. So that that in itself is a reason to do what law says in many circumstances, particularly if you're a government actor. But it's a weaker reason if you're an ordinary citizen deciding whether to obey a stop sign in the desert, right, with no other cars around, deciding whether to jaywalk. There are lots of circumstances in which lots of people treat the law as merely a signal for likely action, which sometimes is, to be dispensed with actually because the circumstances in their view don't apply. That is to say, they're making an independent moral judgment about what to do. Right? There's no question that our legal cultural tradition and our individual psyches have been significantly affected by centuries of authority talk, right? Centuries of the inculcation with the notion that there is a moral source of content-independent right to be obeyed that invests governments with power. I mean, every ancient civilization of which we have good records has the claim, right? You have ancient monarchies throughout the planet claiming that the divine is the source of the leader's right to be obeyed. And we can see how, from an evolutionary perspective, that would develop if certain individuals had distinctive abilities for a community, emerging community that saw itself as bound with an active, engaged divine dimension, it would seem natural to view those distinctive abilities as signalling the will of the Creator that that person be the leader. Right? And Max Weber talks a lot about the routinization of charismatic authority, that the way we got to succession principles was then the self-interest kicking in among those who were so initially well endowed, the desire to perpetuate incumbency beyond what natural ability would naturally have afforded, something that we tenured academics very much are in favour of, is something that led to this notion that the divine blessing passed down through leaders on succession principles or some such thing, some decision-making mechanism had divine endorsement. We can understand why people would think that way, but in fact we don't always behave as if that's true. So I think there's a tension within our individual psyches and in our culture between a long history of authority talk, but an increasing recognition that in fact we use the law as a signalling system. And when we look around the world at societies that have very effective signalling systems and the ones that don't, we see, obviously a very direct relationship to economic and social success, and we do not see an ongoing, very direct relationship between authority talk and the success of the signalling system, right? I mean, if you were, at the time of the Reformation, going to predict whose signalling systems would be more likely to go awry, you'd have picked the places that were being authority skeptical, right? The places that stuck with the strong authority talk of Roman Catholicism. You would expect to have the most efficacious signalling systems over time, and that hasn't proved to be true.
Yes, Professor Alford?
Yeah, just to pick up on Professor Cochran's comments, to pick up on that, I think that the distinction that Steve Smith is trying to make and that he's trying to make is there's a difference between malum prohibitum and malum in se, right? And as much of law is just a coordinating function. It doesn't matter if you drive on the right-hand side of the road or the left-hand side of the road. What matters is that you follow the agreed rules, right, with respect to that. But it's morally irrelevant if it's left or right. Either one is perfectly fine. But obviously there are many other areas where it actually is a value choice that really matters. And I think, of course, you agree with this about whether or not you kill or whether or not you torture. My sense is that you haven't really answered the question about what about those situations that are not simply malum prohibitum, but actually malum in se, wrong in and of themselves. And I don't know that Holmes actually would have an answer to that. I mean, Holmes would say, that perhaps that one generation of imbeciles is enough. And therefore, if you need to sterilize someone who is mentally retarded, then so be it. So I don't know, I guess my question is I don't think that you have answered the question of would Holmes or would Darwin embrace certain types of things, even if it's not in the interest of the larger society. My sense of Darwin is that he would be categorically opposed to something like slavery, even if the powerful thought it was a good thing to do.
Oh, your individual moral theory of the good, whether you're a consequentialist or a deontologist or whatever informs that, or whatever theism or atheism informs it, seems to me to have nothing to do with your view of the character of law, necessarily. They can be wholly independent issues, and in fact, a robust moral realism that views certain things as really wrong and other things as really right is fully consistent with an evolutionary conception of law as just a signaling system, and in fact it liberates such independent judgment about what is morally right and wrong. You're not helped in having a clear idea of certain things being wrong in and of themselves by a legal system that blurs the question about what you're supposed to do when you would otherwise think something was wrong of itself, but the government's telling you to do it, right? You are aided in exercising your independent moral realism by a conception of law as just an information source about what others think you ought to do and what others think on the topic.
The first two rows are very active. Let's go to the back row. Yeah, right here, please.
How to say this quickly? I mean, the question here is who had a greater impact on law, on American law? It's a very, again, I think to echo Cochran's, there's a lot of American law. I guess I want to piggyback onto that. I had the idea, the thought is we have a concept of natural law, and the Declaration of Independence was brought up. And without natural law, it's bringing up again, Professor Thomas, Justice Thomas rather, who strongly holds that the Declaration of Independence is joined the American Constitution. That without such, we wouldn't have our nation and our laws as they stand today. The question I want to pose, sort of, not to either of you, but
then it must be to you.
Definitely your turn.
Is this concept, while evolution as a scientific study should be really separated out from law and from religion, unfortunately it's been put onto everything. The idea of natural law being one that it comes from our very existence as a human being, granted to us through scripture and through a claim to right, as you brought up, but also just through our natural being created in the image of God, which comes from our scripture, but nonetheless, a little circular, but the idea that what is the greater, is that the turning point here? Did Darwin change? Maybe he had no intention of this, but the idea of evolution really put a schism in our culture in that way. And did that cause a greater impact? Since it's caused the idea of the theory of evolution has caused such a great impact, causing that rift saying, no, there is no natural law. We aren't by saying we're no longer created in the image of God, which is essentially what evolution has now claimed. Did that make that cut? There's no Declaration of Independence. Lincoln makes no claim, has no place to go. It's just sort of.
Can I just add one thing before Dan? I think you should take the floor, and then we'll open it up. Remember, there are different branches of evolutionary thought, including theistic evolution. So let's not be overly bipolar in categorizing evolution as necessarily. There can, in fact, be no theistic dimension. So, but
don't have a long time to make
a friendly amendment to what you said very elegantly. Dan.
Well, I think there's a really significant cultural and maybe philosophical question there, which is whether, and I think maybe it's not so much important Darwin specifically, but in a secular world, or at least a world where people don't agree on religious premises, is it still possible to attach independent significance not only to law, but also to ideas of justice or natural or moral rights. And there are certainly people, and this is not I think, a left versus right question. I mean, Judge Posner, I think, is a clear example of somebody who thinks essentially that the idea of rights or justice or law are shibboleths, that a sensible person in the world of Darwin believes in social welfare as maybe measured in certain ways, and sometimes ideas like justice are useful as ways of motivating people, but that basically there's not much to them. Other people, so some people, sort of buy that as the view. Other people like John Rawls have tried to rescue a role for ideas of justice as having independent source, even in a purely secular vision. Obviously there's very deep issues here, philosophically, that I at least don't think I can set you straight. I do think it's terribly important, though. I think it's very important, for example, if those of you who are law students, when you're lawyers and you see that your client, let's say an investment banker, is about to violate the Securities and Exchange Act, whether you tell them, this is a litigation risk. There's a signal here that if the SEC catches you, it could be bad. Or if you say, this is illegal, you shouldn't do it, don't do it. Why not? Because it's illegal. Right? I think there's something significant at issue here. I think it can be exaggerated, right? I mean, Posner would say, yes, one of the reasons not to break specific rules is because you undermine the whole institution of social coordination. So it's not that he's a complete Hobbesian every man for himself. But I do think that there is a significant difference in thinking that when you say you've said something is illegal or unjust or violates someone's rights, whether you think that you've really said something that in and of itself has weight, or whether you think that's just sort of, at best, shorthand for talking about something more real.
Yes.
Professor Farber,
just a little louder, please.
you make a very good argument about the changes that occurred after the Civil War during Reconstruction. And I often wonder whether John Wilkes Booth's assassination of Lincoln generated the strength of the amendments as they ended up being, and whether he should be given credit for those, because the radical Reconstructionists who then framed them. But the question that I have for you is, for good or for ill, no matter how you feel about it, isn't it a pretty strong argument that Darwin influences American law strongly merely because of the concept of evolution gives rise to a living constitution that can be evolving with time and basically changing? And as we move away from the concepts of Blackstone that was solid and move on to that, really Darwin has influenced the Constitution far more greatly than Lincoln. What would you say to that?
Well, I think that's a very interesting question. I mean, I'm putting aside this comparative issue. I think that's a very interesting question. Now, you don't need to be necessarily a Darwinian to believe in evolution. Right? There were people even before Darwin who thought that there was evolution but had some other theory about it. Like Lamarck thought that it was animals sort of striving to, giraffes tried hard to get the fruit that was high in the tree, and because of that their offspring had longer necks. Right? So you could have different mechanisms. But I think it's fair to identify it in an important way with Darwin. And I do think this sort of question of the living constitution and the idea of law evolving is one that may be linked in some ways with Darwin. I'm not sure whether Darwin versus Lincoln is quite the right way to frame it, though. There's a wonderful quote of Lincoln's about how we can't rely on the outworn dogmas of a previous time to face the questions of today, right? And he wasn't much of he didn't really ponder constitutional theory and originalism. He certainly paid close attention when the occasion arose to the Federalist Papers and so forth, but he wasn't really faced with this question in the modern sense. So I'm not 100% sure which way Lincoln as an individual comes out in that. But I do think, maybe there's some argument that you could attribute some of the living constitution to Darwin, in which case a number of leading constitutionalists today would say
well, that was a problem, but we've purged the system of this living constitution idea and returned to originalism. And so, Darwin had his day, but now we're back to the other side.
Except Trop Fidelis lives, the evolving notions of decency of a maturing society, very richly could be described as Darwinian or evolutionary thought. Larry, would you like to comment on either of the two prior statements?
Yeah, I think taking an evolutionary view of the Constitution, let's say, is just that basic notion is agnostic as to what one views as the appropriate mechanisms for the evolution to occur, right? Whether it's so, there is a sense I think one can say about the current American debate about constitutional interpretation that at some level perhaps it's not really a debate about whether text should be read in accordance with their original public meaning, but about which text should be read that way. The issue is in a way whether the morality of the system frees the Supreme Court to read the Constitution's words in a non-originalist fashion, while nonetheless insisting that all other government actors must read Supreme Court opinions in an originalist fashion. If other government actors were free to read Supreme Court opinions in accordance with their own evolved perceptions of political perfection, then Cooper v. Aaron has wrongly decided, that's for sure, right? The other states get to say, oh, I'm going to read this desegregation to mean segregation. So basically, the court is originalist in respect of its own words.
May we use that as a closing word? Or would you like to add?
That's good.
We come to closing word. Our final word.
Well, the only thing I can say is that the world will not know nor long remember what we have said here today.
Would you join me in welcoming back to the podium our dear friend Ed Larson?
Again, I want to thank Morgan and Thrower and Kylie Larkin for their efforts to organize this and pull it off. I want to thank Dean Starr for being in it and Alice Starr for being a tremendous host. These comments today, I think, pushed us to think more about where are the sources of law and where did Lincoln and Darwin and their actions lead us to think about the sources of law and the origins of law. For me, it didn't necessarily answer the question. I will very briefly give you all the opportunity to say, based on your own observations and experiences, not just from our two extraordinary speakers, but from your own teachers and your own experiences, what do you think has actually happened to American law? Not what you want it to happen, but what do you think had happened? And I'll give you three choices which would have, to raise your hand, which would have the greatest impact on American law as we experience it today. And your choices are Lincoln, Darwin, or both. So how many would go with Lincoln here? And how many would go with Darwin? And how many would go with both? So there's a victory for both. I would like to give, if I don't knock it down, one of these to each of our speakers. And if they would like, I'll actually give another one to the others, since they weren't that forceful in refuting the other. I want to thank our speakers will have a chance at the reception that follows to meet with you all and talk with you all. The reception is right outside, ready to go. And again, I want to, for all of us, to one more time thank both of our speakers.